Thank you all for being here. This is the last session of the day, one of the breakout sessions. We're honored that you joined us. As we were introduced, this is core court governance. So are you in here in the right room is the first question I'm going to ask you. This will be some participation. It's not a full thing of participation, but show of hands, you know what the core is. Does anybody know what the core is? Have you been in sessions where they've talked about core? Should be all of you because we mentioned it in the opening ceremonies. Okay. But the core competencies were developed by NACM, the National Association for Court Management, a number of years ago, basically outlining what are the things court leaders need to know about? What are the basic competencies? And all of this material that we're going to be sharing today is just a bite size of that curriculum. The 13 curriculum are out on our website, nacmnet.org. If you type in NACM and think you're going to get to our website, you're going to get to the National Association of Credit Management. So it's nacmnet.org. So let's talk about what you can gain as being a member of our organization. A member of our organization, you can join for $150 a year. What's that? That's a Starbucks, once a month, right? $150 gets you a membership with our organization, and you can join this program, the Core Champion Program, for free. So free, no charge. So you taking this session right now today, you're part of the Core Champion Program. You didn't even know it. So congratulations. So what is the core? I said it's those 13 core competencies that we want court executives, court leaders to really understand. And each of those competencies, really that's about like 3 days to 5 days worth of curriculum. If you go on our website, the actual material is about a couple hundred pages. So like I said, these sessions that we're doing for you for this core program are bite-sized, much smaller. Today we're in the vision module up in that right-hand corner, and that we're under court governance. But if you attend all of these sessions and get all of these core, you will be considered a core champion, right? So the reason why we do this is to strengthen you as managers, as core professionals, giving you the tools needed to do your job. We also created this Core Champion program as a certificate-based program. So that way you can take it back to maybe your administrator, your leaders, and show and it's a nice resume boost as well. And then finally, recognize attendance through certificates. And do we have certificates? If you go through this program, you not only get one certificate, you get 5 certificates. Right? So if you explore all the different modules, if you finish an entire module, and then once you're done with all 13, you get a certificate. And what do you get with that? A new car. No, you don't get a new car. Once you attend a session, you do have to take a test. We want to make sure you guys were listening to that session. And once you're done with that, you've gone through all 13, you do write an article, you do write a little essay, a 2-page essay, and then we review it and you get your Core Champion Award. And this, you actually will get recognized at one of our annual conferences for this award. And if your article's really good, it could be published in one of our publications, Court Manager, Court Express. So that was my public service announcement for all things core. And if you have any questions about this program or anything core related, you can always see somebody, and I don't have my lanyard with me, but if it says board, that means you see somebody raising their hands in the audience. Just see us and we'll explain more about the program. But as I said, today we're going to be talking about court governance. And before I go, Giuseppe, would you like to introduce yourself? I just kind of rolled right in. I have a tendency to do that.
Oh, sure. So I'm still in the morning, to be honest with you. I was about to say good morning. All right, good afternoon, everybody. So I'm your co-presenter, Giuseppe Fazzari. It's a real pleasure being here. I see some familiar faces, so I saw some of you in the morning session, which is good. You're a real glutton for punishment. Follow me around. So Just a little background on myself. I was a public administrator. I was in court management, 20 years. I'm a full-time academic. As I mentioned to you earlier this morning, what I do now is much more easy, right? Much easier than managing people. So, and I'm at Monmouth University as a full-time faculty member there last few years now. So it's a real pleasure being here, and looking forward to any kind of questions, issues, and concerns you're going to raise.
All right. So court governance. We got a little bit that I'm from California because I worked at Knott's Berry Farm. I did start in California and I worked in Arizona. I worked for some great court administrators, some legends in the field, Kent Batty, a past NACM president, Ron Overholt from California, as well as Arizona. And one of my mentors is Marcus Renkensmeyer. Side note, at the end of this presentation, you'll see Marcus's name up there because he was supposed to be giving this presentation. So I think something about a last-minute change-up in the lineup, and you got me. So, court governance. And here's the audience participation part. What is court governance? What does it mean to you all? Come on, you had sugar in the hall, right? Back over there?
All
right.
And customs. The rules and customs that help guide the way that the courts behave.
Yeah, that's the perfect example. It is really that overarching framework, all of the policies, all of the procedures, all of the things that explain how our courts function. And it gives us that overarching, so that way we know what we're doing, right? So why is that important? So we know what we're doing? Is it just us that we need to know?
For the public, transparency, accountability.
For the public, transparency, accountability, making sure people understand what they're supposed to do when they come to our court, how our processes are, what does that mean? Anything else?
Understand our court other stakeholders, and so they understand our court operations.
So it's not just us, it's not just the public coming in, but our stakeholders, the attorneys. What does that look like, right, for them coming in through our processes? So yeah, those are the reasons why they're important. So you nailed it. The framework for our operations. And that not only accountability and transparency, but consistency, right? Making sure that when somebody comes in, they're going to get the kind of the same answer and their case is going to be handled similarly. So having that consistency within your practices. Making sure that we have ways, how are decisions made in our courts? Who are making the decisions? And if you don't have that structure or outlined, then nobody really understands, right? And you might not get buy-in. We'll talk a little bit more about that later. Having that overarching governance also supports that judicial independence, because the judges are there to do judge work. And if then that's their lane, but having all the administrative and all those other structures in place, that helps guide courts just in generally, and lets the judges spend their time on cases. And then ultimately, we want public trust and confidence. And by doing that, we're also improving the administration of justice if we have all of these things in place. We'll dive a little deeper on some of these areas as we go along. So the first thing we're going to do is a little history lesson, and it's interesting because I was listening in on some of the other sessions, and so you might have heard some of these names and references before in the history. We like repeating history, or sharing it. So that way, not repeating it sometimes, but sharing it. So that way, how do we get to where we are, right, today? And we'll talk about purposes of the courts. We did mention Ernest Friesen. He was the founder. I like to call him the great-great-grandfather of court administration, because he did, outline these purposes and responsibilities of the court. And then we're going to delve into some of these judicial administrative principles and how they tie to your governance structure. So it wouldn't be a core governance class if we didn't talk about Roscoe Pound. And who was in Janet's class? Okay, so some of you know who Roscoe Pound, who's heard of Roscoe Pound that weren't in Janet's class. Okay. So he was the dean, and he gave a speech in front of the American Bar Association. And in 1906, he talked about why the public was dissatisfied with how courts were run. And the things that he brought to light were case backlogs, inefficient use of court resources, and just overall administration of how courts run entirely. So what are some of the things that we talk about when we come together as court managers? Backlog of cases. What do the public trust and confidence? Do we survey our participants to find out, people that are coming to our courthouses, are they being treated equitably and fairly? And so these things were talked about back in 1906, and here we are today. And we're still kind of talking about those things. So some other events that impacted the development of court governance in the 70s, there was a very large push for kind of institutionalizing and really creating the court management professional, the court administrators. And what does that look like? So the Institute for Court Management, National Center for State Courts, these were founded, National Judicial College. These agencies were there to help courts develop their leaders, to make executives, and to look at all those things that Roscoe Pound was talking about. How do we do backlogs? How do we deal with unsatisfied people coming to the court?
May I ask a silly question?
Not a silly question.
Was Roscoe Pound, who was he? Was he a scholar?
He was a dean of Harvard.
Harvard.
Oh, okay.
Just a little.
You can tell with the hairstyle.
Okay. Say no more.
So, other trends that impacted the development of court governance, then we started looking at cases. How are they being performed? What is that backlog? So what do we do with backlogs? How do you measure how a court is doing? And so the court performance measurements came out around the 70s as well. Looking at case management rules. How many people have case management policies within their courts? That's part of a structure, a governance structure. What I also liked is, and I think I've heard this in some of the other sessions, is how taking those performance standards, taking those measurements, and then utilizing that information to share with your funding authorities, right? How do you explain to somebody who's going to be giving you money what's going on? One of the arguments I've used in courts is if you're not counting something, then you can't show how much work is being done. And sometimes we focus only on filings and terminations or case aging. But in reality, is that all our work? Oh, heck no, right? That's just a sliver. So sometimes we forget. What about all the phone calls our courts receive? What about all the people that walk into the front counter? Are we tracking those metrics as well? Organizations are focused on improving court administration emerged. So you've got the State Justice Institute, you've got the Bureau of Justice Institute, or administration. You've got all of these entities that actually provide technical support, funding, ways to get training into your courts, help you develop programs. All of these kind of came through during, like in the 70s and 80s, then we started seeing a lot of that to help with governance. So see, some of the key governance principles, we talk about the purposes of courts in Ernest Friesen. There are 8. Do y'all know them by heart? No, okay, I had to write them down too. All right, but number 1, individual justice in individual cases, right? That's the first purpose of the court. Providing a forum for legal disputes, protecting against arbitrary government power, formal record of legal status, deferring criminal behavior, deterring criminal behavior, rehabilitating, separating serious offenders from society, and ultimately ensuring fair and well, I can't even read my own writing, and equality within the judicial process. So those are our purposes of the courts. And you kind of see this under the good governance. You see a lot of those concepts kind of also portrayed in that little bubble, right? You've got accountability, transparency, following the rule of law, being responsive to your public, to the needs of the community, inclusive, participatory, and consensus-oriented. So those are some of the concepts, and you'll hear them a little bit more when I talk about the administration principles as well. And then ultimately, we'll go a little deeper on the principles in the next slide or two, but what's the stewardship role of the court administrator, of the leader of the courts? What's stewardship mean? Having a fiscal responsibility. Usually the term is you're a good steward of the public's money. But it also goes to, again, are our courts being, are we using our resources? Yes, that's funding, but are we processing the cases timely and effectively and efficiently? And being able to look at all those things as well. So here are the overarching principles, and these principles came from a Utah Chief Justice of their Supreme Court, Honorable Christine Durham, and her state court administrator, Daniel Becker. And they wrote up a paper that basically said, if you're looking at your governance structure, these are some of the things you really need to think about and kind of use this as a critique and measure. Do you have these things within your framework, within your court system? Side note, they were also kind of advocating for statewide, and we'll get into state versus local governance. So a unified state versus maybe a not unified court system. So one of the things they argued is that your governance structure is well identified. It's overarching for your entire court system. And it's talking about administration, and it's talking about the different lanes for everybody and who's in charge of what. The second one, and it kind of fell off. There's more to this sentence, that judicial leaders are selected based on competency. Competency, not just seniority or rotation. So these individuals felt that it was really important for us to look at, if you're going to put somebody into a presiding judge role or a supervising judge role, that they have some background or some competency in being that type of leader for your court. We'll talk about the differences in court systems and how judges get into that leadership position in the next slide or two. Principle 3, judicial leaders are focused on that policy level, that hierarching, and not down in the weeds, right? Not in the day-to-day operations, or at least they shouldn't. But then, again, does that look like for every single court? What if it's a one-judge court, right? One judge, one administrator. So we'll talk a little bit about that as well. Overarchingly, court leadership is going to be the one that exercises that managerial control over the resources that support the judiciary. So they're the ones making sure that they've got enough staff, that staff are trained up, that if all of a sudden the caseload shifts a little bit and maybe your civil filings are higher than your criminal filings, that the administrator and management team are able to shift those resources to support that area of the court as well. Okay, principle 5, that the court system should be organized to be efficient. That we're taking out those redundancies, those complexities, and that's sometimes hard, right? We sometimes set things in place and then we just don't look at them. We set a policy, we set a practice, but we don't go back and say, are we being effective? Or do we have redundancies within our system? Principle 6, court leadership should allocate the resources, again, throughout the court system to make sure there is a workload balance. And that might also lead to conversations of judicial resources as well. Because if we understand where the caseloads are as managers, maybe we need judicial resources somewhere else. And then finally, they identified that court leadership should ensure that we have highly qualified, highly skilled, competent employees. Now, how many of you are going through turnover? How hard is it to get people trained and qualified? Hard. Mainly because we get them in, we train them up, and then they leave, right? So how do we, as leaders, look at that? And that's something I think, even though that's a great goal to have these highly qualified individuals, we're always finding things like, okay, maybe our pay, we don't get into this job because we want to be millionaires, right? So how do we incorporate that? How do we get to motivate staff? And if you took this morning session with Dr. Fazzari, he talked a lot about how to engage your employees a little bit better as the court manager and leader. So that's kind of those overarching. And now I want to talk about that statewide perspective versus local courts perspective. And what does it look like when you have a state court, kind of unified court, or even administrative office of the courts that's setting some of your policies in place versus what you're doing at the local courts? Some shared model, leadership models, and then a little discussion about judicial councils and what those look like. So, who here is from a unified system, court system? I see North Dakota in the house. What other states do we have? New Jersey. Who else? Missouri. Okay. So some of these systems, your statewide system, that means what? All of your funding comes from the state, all of your case management, your court applications, all of your IT, all of those structures come from the state? Yes or no? Maybe, depends. So this is when I got, so again, this was not my presentation. This is Marcus's. I'm not blaming, no. This is something that, it's a hard one. It's hard because we say we're unified, but it's like, well, are we truly unified? And what does that mean and what does that look like? So when I see state court planning management and the big picture, those are really a lot of states have gone to that administrative office, Supreme Court oversight, that bigger umbrella that kind of sets that high level policy, high level things. You think about when COVID happened, did your state Supreme Courts issue directives how your courts are going to run? But when it got down to the local level, you might have had some differences, right? You might not have been able to do it exactly like it was prescribed, but usually the state's courts give you that a little bit of wiggle room. But some of the reasons why they really do want a state court overarching is we would like to see some consistency. In California, there are 58 counties within the state. And trying to get all of the 58 counties on one system, that did not happen. But trying to find ways that if you go from one court to another, the forms don't look entirely different. You know, that's a project that they want some consistency, some uniformity. It's a way to share best practices with those 58 courts as well, right? And then they're the ones, if they're state funded and they have all the big bucks, the deep pockets, they're the ones that can do those statewide initiatives and help the smaller courts roll out those projects. And then there's that little thing called management oversight. And I see somebody in the back nodding about the auditing piece. So I think it's not a bad thing, but anybody who hears the word audit, you just immediately go, oh no. But it's, ultimately there to help us be better and find ways to do our processes better and making sure that we're doing things according to our statutes and all of the policies. But then you flip the coin over. And what do you see? You think, okay, statewide's great, but also every single court, we're not cookie cutters. None of us are. From courthouse to courthouse, we're going to be different. It's going to look and feel different when the public walks in to courthouse A to courthouse B. There's 3 courthouses over here on the corner, just a couple of blocks away, right? They look different just from the outside. And I'm sure when they walk in, there's a little bit of different feel to them as well. So some of the arguments for the local courts actually doing all of their governance and having their own structures, they're the ones that are best. They're boots on the ground, right? They're the trial court. They know what's happening within their own court. They're the ones seeing the cases, seeing the people that are coming in, and the types of cases. So they're going to know how many more criminal cases versus civil cases. They're going to know where their resources should go. But they're also going to identify, instead of those statewide big projects, it's like, yeah, that's great that we have this statewide big project, but what our community really needs is this. What we're seeing is maybe we're a rural court and there's not a lot of bandwidth. There's not a lot of ways for access to justice. So how do we innovate around some of those things that are happening in our court? And then the local community connections. Do you have a lot of veterans in your area? So, you might then say, okay, our local court, we really need a veterans court or a homeless court. Or our court was impacted by a lot of opioids, and so we need family treatment courts. So shared leadership. What does a shared leadership look like in your court? Do you have a presiding judge and administrator? Do they talk? Is it a set standard? Or is it just as ad hoc, as needed? Run down the hall? Is somebody on speed dial? I'm getting a lot of laughter from the audience. I don't know about you at home. But that's part of this is governance, is to say, what does this look like? What is the expectation of both parties? What are their roles? What is their lane? What is your lane as an administrator? What is that communication protocol? And how are you communicating? Is it by email only? Do you set up Zoom meetings? Or is it on the calendar? And are you always doing that meeting? And making sure that that communication is clear and that you have that outlined somewhere. And then the other topic we have and that's local, that might be at the local shared leadership, but at the state level, there might be a judicial council. So your chief judge and your administrative office of the courts, your administrator who oversees your state, they usually don't work in a vacuum. They might have a judicial council. In California, I know there is a judicial council and they have 21 members. Chief Justice is on it, but it's also attorneys, it's legislative representatives, it's the trial court judges also, because the directives that are coming down from the Supreme Court to the trial court judges, they want to have some say and input on that as well. So making sure that you have your counsel briefed on what's going on in the local courts, going all the way up, so that way it helps them make those decisions. So there was another way to also get, aside from them being on the council, sometimes they'll create committees. Do you guys have those in your state? Certain committees, maybe a committee on access to justice. I've seen committees, task force on what else? Court security, court-wide security. I think there's a session about that as well here at the conference, setting up a statewide program. We also have It's not just trial judges, though. Sometimes we'll have administrators, and they might be part of that advisory council that help the Chief Justice set those policies. And they really wanted to, if you're having a judicial council, it's more to get away from that. It's just an org chart, and this is who reports up to who. It's not just, the chief making the decisions, period. It's more that collaboration. And what's the best way to get somebody to buy into something? Is to have them at the table, is to make sure that they have some input and they can at least tell their side of the story and say, okay, if you do this, if you implement this policy or program, what are some of the outcomes that you might see and how would it impact my court? And you'd be able to articulate that. All right. Now, today, where are we today? 250 years celebration. We're talking about the rule of law. We'll talk about procedural justice. I'm not really going to go into judicial independence, but that's within the curriculum. And then I'll stop talking and I'll let Joe talk for a little while. He's much more entertaining. All right. Spotlight on the rule of law. So again, 250 years, America, we're celebrating. The rule of law is super important, but these are things when you're developing your structure, your governance, your policies, your procedures, they really should be in the back of your head. You really should be thinking about making sure that, okay, yes, all of our governments and individuals are accountable under law. Laws are what govern what we do. But I like the next one. Laws are clear, publicized, stable, just, and protect fundamental rights. How many have read the law books or your code sections? Are they clear? They're sometimes hard to read, hard to understand. And if they're hard for us and we're dealing with it on a day-to-day process, how do the people that are coming to our courts feel? I think one of that principle really drives a lot of our, when I talked about forms, is a lot of our initiation to make sure that our forms, our websites, all of things are accessible and understandable, that people really understand what it is that's going on. Plain language, you hear that term used a lot. The process by which laws are enacted, administered, and enforced, that they're fair. So some of those things are beyond our control. We might not have the ability to enforce the laws. That might be the law enforcement agency. But, how we are administering the laws within our courthouse. And then finally, that justice is delivered timely. Again, key, timely. Justice delayed is justice denied. So we want to make sure that we're having our cases move timely and that they're being reviewed by competent, ethical, and independent representatives that represent our community. So that's the judicial piece. We want to make sure that our judges reflect our community, but also that they're independent, they're neutral. It's not party lines, it's not any of that. That's why they wear the black robe, the dress, right? That's what I call it. But it's void of any adornments. It's not like NASCAR. It doesn't have sponsored by Weber okay. And independent, free and impartial. So one of the other things when you talk about governance and you're looking at your governance structure, and I love procedural justice. Anybody who's ever heard me talk about things, if somebody mentions procedural justice or procedural fairness, I get very excited. And I heard one of the sessions next door also bring up procedural fairness. So I want to just talk about what's on the right-hand side of this slide, this procedural justice in the courtroom. But I want to elevate it. It's in the courts entirely. But a little backstory about procedural justice, 1980s. This concept came out of the Rand Corporation and Yale University. And they basically surveyed a bunch of people and said, okay, you went to court and you got an outcome. How'd you feel about it? And they really kind of dove deep, asking them a bunch of questions about what made you feel okay about the outcome, win, lose, draw, whatever it was. And they found that there were 4 elements. There was voice, neutrality, respect, and actually understanding. And the voice was that they were heard, that somebody listened to them, be it front counter person, be it staff on the phone, be it the judge. Sometimes we hear your day in court, but it wasn't just about the judge. And that's why I wanted to elevate it out of just the courtroom. Neutrality, that everybody was impartial, neutral. That means walking into our front door, were they treated the same or were they treated different than other people walking in through the front door? What happens when you walk through the front door of a courthouse? Security, you get screened. Are people being screened similarly or differently? Depends. Do you have a line for attorneys? Do you have a line for employees? What does that look like to the public? Just keeping these things in mind, as you're going along. That they were treated with respect. And again, respect could mean a bunch of different things. Good morning. How are you? How can I help you? Where do you need to go? But it also could look like, I've told staff before that 5 minutes to 5 and the line is out the door and all of a sudden staff are kind of doing the, hey, let's get the show on the road kind of thing. No, we got to make sure everybody's treated equally and fairly and that we're respecting their time that they took to come and get their things resolved. It could also be, how long are they waiting on the phone? Are we respecting their time that way as well? Understanding, like I said, is not on the slide, but do they understand the court procedure? Do they understand what's expected of them when they get there? Do they understand what happened to them? Do they understand their next steps? If they do, the outcome, then they're going to say, okay, if all of those things were in place, I got a fair shake, no matter what the outcome. They're going to see that the court was treated them well. So I like this slide because then it also has the flip side. Are we doing this for staff as well? Because that is a huge piece. If we're we have to make sure that we're treating our staff the same way. And if you look at some of those things, you might also recognize who's familiar with court tools. There is an employee satisfaction survey that you can give as an administrator, as a manager, and it's part of one of the court tools, and it asks some of these questions. Did my employer listen to me? Are they fair? Do they treat me with courtesy and respect? And then, do I understand the policies and procedures? Do I know where to get my questions answered? I think understanding is another big piece of this puzzle as well. And ultimately, if those 4 things, then that's going to build that trust within the system. So, like I said, procedural justice, it's one of my favorite things. I think it's super important, and I've seen courts around the nation starting to use it as onboarding. The International Association for Court Administrators, I saw a judge talking about mindset and training up brand new judges within a mindset, and she was talking about procedural justice. So that made me super excited. And now, a word from our sponsor. No.
All right, thank you. There's a big difference. Oftentimes when we think of the courts and you talk about the public, sometimes we make the mistake of thinking as the law, the courts in terms of law. And what we're referring to the law basically is the substantive piece, meaning legislators go out, they make the law, the executive branch go out and enforce that law, and then obviously the judicial branch comes to us, and then we interpret that law. But that's only one half of it. In fact, in most instances, that's really not going to be the part of the law that resonates with the public. The part of that's generally going to resonate with the public is what Tina was talking about in terms of the procedural law. So think of the procedural justice as basically that law in action. It's the difference really between the academic part of something, which is the substantive piece, and the procedural piece is the practice of it. So you all are responsible for the really, in my opinion, I would submit to you, the more important aspect of it is the application of such thing, right? A policy is only good policy if it works. The law is only good law if it actually works in practice. And you don't know if it works in practice by reading about it. It actually has to go into the real world with real people in real application. It says it doesn't work, it does work, and it's usually not those two extremes. It's usually some of it works, some of it doesn't work. That's the procedural part. And that's an enormous part of what, frankly, court administration is about, is that law in action. So the policy in the law is not good policy in law because it makes your stomach feel good, right? It makes me feel good. No, it's only good policy and good practice if it actually works in that practice. So in loosely coupled systems, what is a loosely coupled system? So I just say that term, loosely coupled. What does that mean to anybody? There's no wrong answers. Connected but flexible. Pardon? There is no boss. Well, there is none. There's yes, there's lots of them. It's not that there aren't any. There's many.
There's like 2 lanes.
That's fantastic. And if she didn't cheat, we didn't have this conversation. But I'm gonna talk about those 2 lanes. So think of it almost like a 2-lane highway, and hopefully it's going in the same direction, right? Because you could have a 2-lane highway, but they're going in opposite directions, right? So this concept of loosely coupled organization oftentimes comes up in the courts, but the courts are not the ones who came up with this terminology. It actually originated in higher education administration, actually, by a guy by the name of Carl Wick, W-E-I-C-K, if you want to look up some. So he's the one who really kind of, and I think it goes back to the 70s, if I'm not mistaken. So he came up with this concept of loosely coupled organizations that we've made application to the courts. So I'll give you the background on it, then I'll share with you how it's related or interconnected and how we can make the same application in what Mary McQueen has come up with a better term, frankly, but it's called productive pairs, right? But it's loosely coupled system. Another way of thinking of it is if you think of it like silos. That's another way of thinking of it. Like if you're on a farm, not everybody's from the city like me, right? So if you're on a farm, there's a silo. What do they keep in silo? Grain? Is grain? Okay, so it's grain, right? So think of it like a huge farmland with lots of silos, and they're all on the same farmland, but they're in individual silos. So court governance, really, the analogy then, is there some way, right? You could stay in your silo lane, but how can we connect it? So I could see if you're running low on grain or whatever they keep in there. You follow me? So think of it, that's another way of kind of, another kind of metaphor to kind of make it sticky, I guess, right? Okay, so Carl Wick comes up with this idea of loosely coupled systems or organization. He makes application of this in higher education. And he said there are different parts that are connected in that academic setting, but only weakly. There's not strong interconnection. And there's a positive and there's a negative to such a thing. The same exact kind of dynamic that occurs in the court. Now, to the extent that it's weak or strong, that's really where the leadership comes into play. That's why lots of these, if you attended my session this morning, I talked about those fundamentals. They're not isolated modules or fundamentals. They're permeable. And when they work, they're very symbiotic, right? They're permeable. They work together. And they only work together ultimately with the important people that you're putting in the chair, those leadership chairs, right? Judge and administrator. They have lots of autonomy. They're related to one another. They don't immediately or strongly affect others. So they indirectly affect one another. They're on the same farmland, right? But those silos are still separated. So In the academic setting, it would be like academic departments sort of control their own curriculum. True. There's lots of academic freedom, so faculty control how they teach courses. Also true. Administrative policies that are created, filtered down, but when those administrative policies filter down, they tend to be uneven, and the timeliness in terms of how they are adhered to can also be fast, quick, and somewhere in between. Same is true for the courts. And so changes oftentimes when they occur in these loosely coupled organizations are slow, they're uneven, they're hard to centrally control. So my experience is managing trial courts in New Jersey. So New Jersey is a highly centralized system. I actually was in the system many years ago when it was centralized, but there was a little bit more flexibility and creativity involved. And it's since changed a bit, right? So I don't know, somebody else from Missouri, who's from the Show Me State? Somebody said they also had a centralized system. Okay, bathroom break, I guess. Okay, so anyway, even though you have a centralized system, when you have loosely coupled organizations within those systems, because of judicial independence, autonomy, and leadership that's accountable at those levels, again, it tends to be uneven. It tends to be slow. You have control. There is a relationship, but it's indirect in nature. So just like to protect judicial independence in an academic setting, it's the same sort of thing, right? You're looking to protect that independence. Okay, so how does this kind of relate? I gave you some insight here in terms of how it relates to the courts, but there's generally 4 or 5 ways, and they sort of dovetail into these 5 core characteristics. So, because organizations like the courts, like universities, and the other sort of example or the parallel would be hospitals, because they're loosely coupled organizations, you can't basically just simply dictate. You can't rule that way. You can't manage that way. And if you do, your success is going to be minimal, and perhaps even only on a short-term basis. So when you're thinking of court governance, therefore, because this is the key dynamic of such a system, you have to rely on other things. Persuasion. I've got to do a you perspective, right? I have to see it from your perspective. I have to try to influence it from your perspective in order for you to do. So what does the Cuba Gooding Jr. say? Help me, help you, right? So you've persuade them, influence, negotiate, consensus building, right? Creating allies, showing, hey, what's in it for me? Rather than any kind of strict managerial kind of control, that won't work. So what are the characteristics? So I shared with you some of the higher ed pieces. On the court side, you have judicial independence, just like you have faculty and you have academic autonomy. That's why Carl Wick's model is very similar to that of the courts. Judges, basically, that independence, judges generally, in the singular sense, control what happens in their individual courtrooms, right? They schedule, they do exigent matters, what they consider to be exigent matters, individual courtroom procedures, their individual staff, evidentiary rulings, backlog, sentencing decisions. If I'm the PJ, I may disagree with how you're managing your court, but there's only so much I can do, right? There's only so much I can do. There's that level of judicial independence. So the PJ cannot dictate how a judge is going to decide or manage a particular case. That's why they're there. They got appointed or elected for that reason. You can't tell me what to do, right? If you think I'm doing something wrong, but my backlog's to the roof, I can't say, hey, you got to do it this way or you're fired. Good luck. So I have to use other kind of avenues in this system when you're thinking of court governance. Number 2 is there are separate professional groups. So if you ever ask a judge in public, what do you do for a living? They don't say, I work for the court. Judge, do you?
I definitely don't tell them I'm a judge.
Right, well.
I say I work at the courthouse.
Oh, you do? You work at the court? Then you would be more of an anomaly. So most judges, they say, I'm a judge.
Because then they judge you for being
They judge you for judging you. This is good prestige, though, right? So, and similar in university settings, people ask, oh, what do you do for a living? They don't say, oh, I work for XYZ University. They say, I'm a faculty member, I'm a professor. Oh, where? What do you teach? I'm a judge, where? So there are these professional core kind of stakeholder groups that are separate. Not only that, there are multiple professional actors within the court system that are completely separated. These stakeholders that you have no control over, but they still could dreadfully impact what you do. And so, and obviously prosecutor, defense counsel, right? Corrections, law enforcement. In New Jersey, we're one of the exceptions. So probation falls under the purview of the courts, but in other systems, probation office is separate and apart. So that's another entity, right? Clerks, if you have a county clerk, that's still another entity. So you've got all of these professional kind of actors coming into the same organization. It's hugely complex, hugely, right? In some ways, you feel like you're herding cats. We have the same kind of situation in university settings. So administrative reforms also spread unevenly. So if I do a program or a policy and it's being handed down from the AOC, software, ADR programs, scheduling, et cetera, the adoption of such things can be uneven. They can be varied. That's that's also indicative of loosely coupled organizations. And finally, multiple levels of authority, not a singular level of authority. Who's reporting to who? You're like an equal among peers. The assignment judge in New Jersey, who's the chief judge of that particular trial court, she doesn't make that much more money than a regular judge. Why would you want to do such a thing? It's not for the money. That's why. That's why. It's not for the money. It's $5 a gallon for gas. It's not for the money, right? So you're an equal among peers, essentially. Multiple levels of authority, multiple different districts depending on your individual system. So no one individual, what Tina was mentioning earlier, no one individual system, right? I can't give you a model, say, hey, use this model, this will work. No chance. No chance. It's a very complicated system. A very complicated system. Okay. How does this thing work? Okay. Okay, so court leadership teams. This is a collaborative leadership relationship. So what Mary McQueen is talking about when she refers to productive pairs, that's a great term actually. We're talking about a relationship where these two entities come together to become more productive. And if you're doing it right and doing it effectively, you're also more efficient. So courts will work best under these, when these two leaders, the presiding judge or assignment judge, whatever you call her, right, or him, salute, right, and the court administrative side, right? You have these two groups that come together. And when these two groups operate in a coordinated fashion, that's what makes them effective. That's what makes them efficient, and that's what makes them productive. So you could be unproductive if you're going around two lanes in the opposite direction, or if you're going down the same line, then you're going to be productive. And so it's bifurcated if you think of it like this. So each bring a different level of authority and expertise. So on the chief judge side, that person, she's going to bring judicial leadership. She's going to set the vision. She's going to set the policy direction. She's going to protect judicial independence. She's going to make it her business to make sure that the judges rule in the fashion that they should be ruling on with independence. She's also going to represent the court in judicial committees, to the judicial community, to the bar association, to the legislature, to the executive branch, maybe to the local bar, state bar, other legal groups, right? Other community stakeholders, educational institutions, the National Center, institutes such as this. On the other side, the trial court administrative side, the court executive side, he or she is going to manage the operations, the administration. They're going to oversee budget, staff, facilities, implement those policies, see the operationalization of that judge's vision and the mission, and provides organization and management expertise. So if you ask an administrator, what do you do for a living? They're not going to say, I'm a court administrator. They're going to say, I work for the court, so I'm a court administrator in that fashion. And most people say, the next question I often used to get was, oh, are you a lawyer? No, I'm not a lawyer. And what do you do as a court administrator? How much time do you have? Right? So I used to use the same exact analogy when I was trying to explain my job to people and trying to explain it's the best job in the world, right? And there used to be a judge that says, you know, it wasn't for the people, this would be a fantastic job, right? He retired. Anyway, so if you have the court administration and it says, well, this is the analogy I would give. You say, well, you know, you go to the hospital, and they said, yeah. You know, you have patients and doctors? Yes. Well, we keep the lights on. We make sure that the financing is right, the IT, the case management, everything you see behind the scenes, we're responsible for. So we're running it. We're running the real estate of that place. Very important job. And it's so important that if we're doing it right, the judge doesn't have to worry about it. She could concentrate on ruling, creating that direction, moving that vision forward. You follow me? So this, what Mary McQueen is talking about is you're doing that so you're going down that lane of highway. And the better, more efficient, the better communication you have with the judge, the faster you're going down that highway. It becomes efficient, becomes productive. So, there's two things that will make it productive. Number one, it's considered productive, quote unquote. Number one, judicial legitimacy and authority comes from the judge. Remember, I said it's bifurcated. So the legitimacy, the authority piece comes from the judicial side. From the administration side, the professional management and the operational piece, that expertise comes from the administrative side. Together, you can move reforms better than if you did it in an isolated state. So let's go back to my example that I gave you about that farmland. You've got the two silos. You could process more grain when they're connected. Then can they process it by themselves? Yes, they can. But you could process more and do a better job at it if the two silos are connected. That's what makes them productive. If you're isolated and you're in your lane and I'm in mine, but we're potentially going in conflicting ways, it's not productive. It's not efficient. It's not effective. And who loses is your staff and the customer base, right? The public is going to lose it. So there are certain things that when you have these executive teams, what these characteristics, so there are characteristics. From my own experience, I'll tell you, I could go into a courthouse. I spent a year in Nigeria, and this is universal. I don't care where you go in the world. I spent a couple of years in Ukraine before the war, right? So I spent a couple of years in Ukraine. I spent some considerable time in Nigeria. And it's universal. I don't care what court you go in. You could spend a couple of hours in that court and have a conversation with the chief judge and the chief registrar or the chief administrator or whatever they want to call themselves. And there are characteristics that are indicative is if I could tell you if that pair is productive. It doesn't take that long. If they trust one another, if they have a mutual trust, that's indicative of a productive pair. If they respect one another, I respect you, judge, and she respects me, you got a productive pair. If they have conversation, they meet regularly, they text regularly, right? They don't have to go to barbecues with one another, but if they're in constant communication with one another, they have each other's phone numbers. That's indicative of a productive pair. If there is a clear division, judge, that's your lane, this is my lane, and we have an understanding that that's your lane and this is my lane, right? The judge is gonna, what do you think? If the judge is asking me what I think, that's a productive pair, right? If they have the other thing is if they have a unified message. So I used to tell my judge, hey judge, listen, here's when I used to first start working with any new judge. So if it was at the division level, like the family part, the criminal part, civil part, or as high as the TCA, if I'm working with my assignment judge, I'd have the same speech with my judge first week. Hey judge, listen, I love you and I'll do anything for you. As long as you don't tell me to do anything illegal or unethical, I'll do it for you. But when we have conversation, Judge, I'm going to be candid with you. I'm going to tell you what I think. I'm going to give you all the information you have, Judge, that's available to me to make the best decision with the available information we have. If you decide, Judge, to go against what I'm recommending, it's no problem at all. I'm going to walk out this chambers as though I made that decision with you. That is indicative of a productive pair. If she makes a decision, I'm not telling my staff anything different. Even if I disagree with it, I'll just wait for it to fail. That's all, right? If she goes with my recommendation, she's not going to her respective jurists and telling them anything different. So we're not going to be in conflict. There's none of that infighting. That's indicative of a productive pair. Oh, sorry. So the judge will get buy-in, right? So those are just some key points, okay? Okay, so the goal is to have this coordinated leadership. So you have this executive team. So who's on your court management team? So in New Jersey, my experience was we had this executive level function. It was very, and the two courts that I worked, Essex and Union, Essex was highly organized. Very good productive pair. The Union one, I also had a good productive pair at my level, at the highest levels, but the productive pair in the other divisions was not as strong. Actually, it was non-existent. I don't work there anymore, so I'll be honest with you. So it was non-existent. And so I brought some of those good practices and measures from Essex into Union. And I'll be honest with you, where I cut my teeth all those years in Essex, I use those same kind of principles and practices no matter where I go in the world. And I teach it to my students who have interest in judicial administration. Same deal, right? So the changes that you should consider when you're looking at these things are you establish regular meetings, you present, as I mentioned, one voice, you spread responsibility, you use data. Data is your friend. Data is your friend. Right? You can't manage what you're not measuring. I'm sorry. You can't be threatened by such a thing. You invest in joint leadership training. So my judge and I are going to change management. We're going to backlog reduction. We're doing strategic planning. She's not poo-pooing those things. She's coming with me. The presiding judge of civil, family, criminal, they're going to those same trainings with their division managers. They're meeting monthly. We're meeting quarterly. We're sharing data. We're promulgating that data. Good job, bad job. Get better, you got worse. And you develop this shared strategic kind of vision. So what changes should you do when you're looking at this? I'm not going to go through all of them. It's in that attachment. I'm not going to go through the verbatim because everyone could read it. So, and we're running out of time. So the changes that you should consider when you're talking about the court governance thing is you'll see it inside the 6 changes, okay? The 6 steps. One of the key pieces I want to talk to you quickly about, which one is it? Step 2. Yeah, step 2. Okay. Step 2, the court culture. So there's a lot of literature on this. Ostrom and Hansen, they came up with this idea of what's called the court culture, and he divided it into 4 typologies. There's a consensual, there's a network, there's a hierarchical. What's the other one? Communal. So this to me is incredibly important. Incredibly important. Court culture it envelops everything. It's the most important aspect of any organization. It will make it or break it. And if you're a leader, you accept it, you adopt it, right? So in Nigeria, they have this saying in Nigeria. It says, I wasn't here when they buried this body, so don't ask me where the head or feet are. It sounds bizarre, but there's a lot of sense to it. So it does relate to court culture because you weren't here when they developed or put this thing together and there's a mess here, but you're responsible. You have to exhume it or don't take the job. Give it to somebody who wants to be the leader, not someone who just wants to sit in the leadership chair. So this is very important with respect to understanding that court culture. And I gave that analogy earlier in the morning. It's the garden salad with the different ingredient, it's the dressing. So if it's blue cheese and it's rancid, then rinse it. Put the balsamic, which is much better anyway. Okay? The last one I want to mention is the six, define, where you're implementing and communicating, where you define and communicate. Because you have all these professional people in the organization, it becomes very difficult. Salud. So what happens is if you have this step 6, what's important, you have to answer the question, what's in it for me? You've got to think about the prosecutor, defense counsel, the judges. When you're thinking of your governance and why people should follow it, why you should organize it, you have to go back to those people and ask yourself, how can I sell this to them? What's in it for me? Because that's where people's minds are. This is going to be a lot of work. We're meeting monthly, and we're going to have an agenda and minutes and an action list. And before the next meeting, my name is going to be on the action list, and you're going to ask me if what I did between this meeting and that. Yes, that's what we're doing here. That's court governance. Hello. Somebody's got to work around here. Really? Yes. If it's not a part of their culture, they're not going to like that. They're not going to like that accountability. But you've got to show them what's in it for them. Why is all that important? Why is that accountability? Why is the data management and measurement important? Okay, so this thing is fantastic, so I have to share it with you. So it's not mine. I wish I did. I'm very envious of this model. This thing is fantastic. You want to manage complex change? I teach an entire semester on just this model, right? So I've referenced this model in a lot of different writings that I have. This is one picture gives you everything you need to know. You want to manage change, complex change at that, just follow that. And if you're missing any of those parts, that's the outcome you're going to get. If you don't have vision, skills, incentives, resources, action plan, that equals change. And if you don't have that, it's going to equal the other thing that it equals. That's why it's so hard. So I could talk to you about an hour and a half about this, but unfortunately, we don't have the time. Okay.
This is not in your slides on the app, so you can either take a picture of it, but we will upload it for you.
It's not mine. It's not mine. I don't take credit for it, but I have referenced it.
I love all the cameras being out.
Yeah, all right, that's good. Yeah. We hit a little bit of a home run.
And like I said, it will be uploaded into the app at a later.
Okay, so the evaluation. You know the funny thing about evaluation, people don't like it. And they don't like it for 3 reasons. Cost, because it costs money to evaluate something. It's threatening, because I have to be accountable. And if I don't want the change you're doing, we don't evaluate it, is a very good means of keeping status quo. That's why people don't evaluate things. But ironically, it's the most important thing you can do, because if you don't do it, then program, policy, court, wherever is destined to succeed. That's not true. That's not your job. You have to evaluate. If you're not evaluating, then what are you doing? How do you know? Every semester, my students evaluate me. You're going to evaluate me and Tina at the end of this. It's like, I don't want you to evaluate me. Why not? If I stink, let me know. Right? If I'm the worst professor, I tell my students, if I'm the worst professor you've ever had, fine. I'm a big boy. Let me know, but tell me what I can do better. So you're not supposed to be scared of evaluation. So there's 5 points to evaluation. It's input, activity, output, outcome, impact. I'll say that again. Input, activity, output, outcome, impact. Output and outcome are used synonymously. They're completely 2 different things though. So the input are those things that you're using, money, funding, software, the things that you use in order to get that program governance going. Activity are the things that you're physically doing, right? So you create guidelines for that remote hearing software that just got instituted. That's activity. You follow me? The input is the money that you put together to buy that remote hearing software. The output are the quantities or the levels. So for instance, the number of cases or the number of PSIs, the number of cases that are being processed by that remote hearing. And outcomes are the benefits that are derived, and the impact are the higher level objectives. So the increase in public trust and confidence by virtue of the fewer default hearings, for instance. So they're separate. So you're organizing things along that sort of those 5-point models. That's how you evaluate in terms of the internal and the external piece of it. So the last piece I'll tell you, because we've all run out of time here, is the differences between quantitative and qualitative. That's also sometimes used synonymously, but they're completely different spheres. So the quantity, think in numbers, and the quality, think in terms of quality, right? You're thinking of focus groups, interviews, content analysis, field observation. On the quantitative side is when you're doing evaluation that deals strictly with closed-ended questions, survey instruments, something you could tabulate on a spreadsheet. Your administrative data sheets, those kinds of things are quantitative. Those are the two spheres in which your evaluations are done. And there's all those different examples of the different methods or instruments by which you can do those quantitative and qualitative. Okay? Yes, Judge.
Who does the evaluations? Is it internal or is it the external stakeholders? Is it just the judge? Like, who does it?
So it could be. That's a great question. So when you're in the court governance, then you can have that conversation and decide who do you think should do it. So I did a pupometer technology evaluation once for my judge, and I told the judge, listen, I'll do this for probation, but I don't have a dog in this race. She goes, that's exactly where I want you to do it. So the person who should be doing the evaluation, I don't care if it's internal, external, but whoever does it shouldn't have any kind of dog in the race.
Okay.
So that they could do it in a neutral, impartial, unbiased fashion. Sorry, we ran out of time. I had a fantastic pizza parlor kind of example to share on those inputs, but next time.
Thank you so much.
Yeah, thank
Please
you
join
all.
me in thanking
I
them.
appreciate you. Safe travels.